Welcome back to Citizen Weekend, and as I promised at the very start of this news hour, I am joined in studio by Demas Kiprono, who is the Deputy Executive Director, ICJ Kenya, that is the International Commission of Jurists Kenyan Section. Karibu sana kwenye studio. Yes. So tonight we're getting into a conversation on protests and human rights, with zoning in on the question of bail and bond. Yes. But first, allow me to set the stage for this conversation. And over the last week, that is on the 15th of July, we saw the Interior Cabinet Secretary, beg your pardon, Kipchumba Murkomen, point an accusatory finger at the judiciary for granting lenient bail terms for protesters. Flipping the coin, the very next day, we saw drama at the Thika Law Courts, where mothers of suspects arrested during the Sabasaba Day protests and charged with robbery with violence were aggrieved by prohibitive bond terms of 300,000 shillings. This is against a backdrop of suspects charged with terrorism over the targeting of government facilities. And Kenyans online have been raising funds for the release of protesters.
Surely 50,000 shillings on after invading an hospital and interrupting a cesarean operation. Only 50,000 shillings were granted as cash bail. These lenient bail terms are unacceptable.
Dalalisheni maskini kabisa, hii kufikia direct. Dalalisheni maskini kabisa, lakini tulikuwa na watu kama Mobutu Sese Seko. Murkomen unaongea vibaya sana ukisema 50,000 ni kidogo. Mnaongea vibaya sana, lakini mjue hawa wenye mnafinyilia ndio walimchagua.
Hakuna mtu hapa akona pesa.
All right, Demas, let's take a look at what the Constitution of Kenya says, where the rights of arrested persons are concerned, and that is under Article 49 of the Constitution. An arrested person has the right to be released on bond or bail on reasonable conditions pending a charge on trial, unless there are compelling reasons not to be released. And it continues to read that a person shall not be remanded in custody for an offence if the offence is punishable by a fine only or by imprisonment for not more than 6 months. So that is what the Constitution provides on bail and bond. There is the bail and bond policy, the guidelines that were adopted by the judiciary in 2015. But before we get into that, we've seen Boniface Mwangi this evening carted away by police. His wife says they talked of terrorism and arson as they did so. What do you make? He's the latest in a growing list of persons accused of organizing the protests or doing damage to government facilities that are being charged with terrorism.
Yes.
Your thoughts?
The Prevention of Terrorism Act was enacted in reaction to the reality that Kenya has faced a lot of terrorism attacks, serious attacks. And terrorism is defined under international law as any act of violence directed towards a people, and it is meant to compel the government, intimidate the people, or an international body to do or not to do something. And so one wonders whether that context applies to terrorism when in the context of protests. And so when you look at now the Prevention of Terrorism Act, the definition of terrorism is quite broad. It is quite broad. It has lists of acts of terrorism. So, for example, an act of terrorism is harming others, harming public health and safety, harming national security. But it also says that terrorism can also be interfering with systems, interfering with national security, compromising service delivery. However, there's a rider down there in the definition that says that if this interruption of services is done in the context of protests, demonstrations, or labor action, it does not apply to the Prevention of Terrorism Act unless the actions were done to cause harm to others, destroy property, and four other things in the list. Further, the Prevention of Terrorism Act speaks to the aim. So all those actions are aimed to intimidate a section of society, intimidate the government or international body in order to compel them to do something or not to do something. And thirdly, to disrupt any economic, political, religious, and social institution. And so we find that the Prevention of Terrorism Act is quite broad, but we all know how and why the Prevention of Terrorism Act was passed. It was passed because of the Al-Shabaabs and so on and so forth that Kenya has suffered and continues to suffer.
All right. Yeah. So could the decision to charge with terrorism be so that these people are either not released or that they face prohibitive bail terms?
So under the Prevention of Terrorism Act, Section 35 allows, first of all, the government to hold you beyond, so it allows the government to apply that you are not given bail. That's number one. And it allows the government to hold a person for 30 days and then keep renewing those 30 days. And this is as a result of the Security Laws Amendment Act.
Wait, so hold you for 30 days, is it without charge or?
No, even after being charged, like even as you're going through the criminal justice process, your case, it allows for you, that person to be held. And you understand that because of the context of terrorism that I've spoken about, this was meant to ensure that people who are dangerous to society are held. However, we challenged these sections in the Prevention of Terrorism in the Security Laws Amendment Act of 2014. However, because there was that judicial oversight after every 30 days, it was allowed to continue. Be that as it may, such a serious offence also, when it comes to bail and bond application, would attract very stiff conditionalities. Yeah. Yeah.
All right. So we have a conversation around bail and bond when the judiciary sits, a judge sits, or a magistrate, and an application is made for bail. Yes. What are some of the considerations? What are some of the factors that come into play?
So, first of all, the right to bail and bond is a constitutional right, and it was really conceived out of the need to preserve the presumption of innocence and also your right to liberty, even as you go through the criminal justice process. And usually, when a court sits down, it looks at you. It looks at you, and whether you're a flight risk. So, will you disappear from the jurisdiction? So, will you attend court? Whether you will interfere with witnesses, or whether you are likely to commit another crime. And so all these considerations are made from case to case. But the bail and bond guidelines, which was really developed out of a very consultative process, is meant now to regularize how judges and magistrates dispense this right. Because initially, this right came after the 2010 Constitution, initially bail and bond was being given in an uniform way. One judge would give exorbitant conditionalities, another would not, and so on and so forth. So this was supposed to harmonize the whole process, which also emphasizes that it's a right, but not absolute. That when you are denied bail, the court needs to give you written reasons, and there is a bail and bond trial. So it's a trial within a trial to see whether you can be released to society. And it even involves someone writing a report on your ties to society, whether you are likely to run away, whether you are likely to interfere with witnesses or victims, and so on and so forth.
Okay. So does it stipulate, like, the amounts, a minimum, let's say, for a robbery violence charge, for example, that this is the maximum that you could compel the person to pay for bail or bond, or a minimum? Does it have specific figures?
Yes, it has ranges. It has ranges. But, we live in a very unequal society. And as that mother has said there, when she said 50,000 is a lot, 50,000 is a lot to a poor person. 50,000 to a rich person might not be anything. And we live within a certain socioeconomic reality in Kenya. And so even as judges, for example, retire to make those decisions, they should they should make those considerations because everyone is different. But the more serious the charge, usually the higher the conditionalities.
All right. Given recent events, how things have evolved, do you think there is merit in what the Interior Ministry is calling for instance? Could it be time to review the bail and bond guidelines?
Well, the government is a stakeholder in ensuring public safety, national security, and so on and so forth. And it is a member of the National Council on Administration of Justice, which is actually the body that came up with the bail and bond guidelines. And so I believe that there are channels that can be used to have this discussion. Yeah.
All right. There are those who take an alternate view, and they say, first of all, the executive should not be interfering with the mandate of the courts. We saw a statement from the Judicial Service Commission which advised judges to exercise discretion, fairness, proportionality, and their discretion. Is the Interior Minister, in your view, the Cabinet Secretary, did he overstep?
So this is a country where we have separation of powers. And we also have freedom of expression. So as much as it is the minister's right to express his concern, that cannot and should not intimidate judges into falling in line, because the judges and magistrates fall within a whole other branch of government. Mm-hmm. Yeah.
Does it amount to intimidation? The former Attorney General, who also happens to have been the former Speaker of the National Assembly, Justin Muturi, said this is tantamount to intimidation.
I wouldn't go that far, because our judiciary, the way we know it, is that it does not take instructions from the executive. That is an opinion of a person in the executive, but it has no bearing on a judge when they sit down.
Mm-hmm. Yeah. All right. Yeah. Could this be an attempt to curtail freedoms by calling for more prohibitive bail and bond terms?
So our freedoms are set out in the Constitution. For your freedom of expression, the right to peaceful assembly, and so on and so forth. And the only way that right can be limited is in accordance to Article 24. In terms of what is reasonable in an open and democratic society. And so what we need to do as a country is that abide by those that spirit of the Constitution, that to ensure that everyone has the right to do what they want, as long as, for example, they are not harming others, which are all set out in the Constitution. And it is upon the person who is trying to limit any right under Article 24 to justify that limitation. So it is upon the government to justify what it wants to do and how it wants to do it. And it has to pass the constitutional test. Mm-hmm. Yeah.
So, we've seen Kenyans online rally to raise funds for those who may not be able to raise the bail or the bond. Is there provision for a review of terms if a person is not able to, like you said, people's economic realities are different?
Yes. Usually you can once a bail determination is made, there are procedures for you to go back to court and say, I cannot afford this, and the court can review it downwards. Mm-hmm. If it sees merit in your application.
All right, but based on what we've read from the Constitution, we begin from the basis that everybody has a right to bail and bond.
Yes.
But now,
there must be compelling reasons for you to be denied that right.
All right.
And those compelling reasons are you likely to
flight risk? Again? Are you a flight risk?
Yeah. Mm-hmm. Yeah. Are you a flight risk? Are you likely to reoffend? Will you interfere with witnesses? Are you a national security threat?
And does the court consider the economic realities of the person? Because you talked about a report.
Yeah.
Yeah.
Yes, it does, and perhaps we think that it should do that even more in terms of looking at the person as they are, because you cannot, not everyone is uniform in terms of their financial capabilities, and exorbitant bail and bond conditionalities are actually indirectly denying that right in the first place, because if you cannot afford, you'll go to remand. Yeah.
All right. So this is a situation where we've even seen courts torched. Are you convinced that would this be a litmus test for the courts?
So this comes in the backdrop of the protests that happened, yes. And we know that there were also a lot of offences that took place during that period. And so there are allegations of sexual assault, looting, robberies, and so on and so forth. It's the government's duty to arrest those people and prosecute them according to the law. It is the judiciary's duty to ensure that justice is not only seen to be done, but is done. And all these frameworks already exist in our laws.
All right, because the Chief Justice herself called acts such as the torching of courts as acts of terror.
Yes, I wouldn't go that far, but they are criminal acts. Yeah.
All right. Yeah. So your concluding remarks on this subject?
My concluding remark is that our Constitution speaks for itself in terms of our rights and responsibilities, and all arms of government should stick to their mandates, and perhaps also it's a time for us to reflect as a country on how we are moving forward in terms of exercising rights, while also acknowledging that this is a collective society where we all have to live with each other. Yeah.
All right, thank you for speaking to us this evening. Dimas Kiprono, Deputy Executive Director of the International Commission of Jurists Kenya, and we're discussing protests and human rights. We take a break, but coming up,
rearranging the skyline a building at a time.